Welcome to Ediscovery Leaders Live, where I get a chance to chat with luminaries in Ediscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI Ediscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in Ediscovery. Thank you for tuning in. Welcome to Ediscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal, and each week I host one, and sometimes, like this week, 2 episodes of Ediscovery Leaders Live, where I get the chance to chat with luminaries in Ediscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select Ediscovery Leaders Live. Our guest today is Carolyn Southerland. Carolyn is a senior e-discovery consultant at CDE, Construction Discovery Experts. Carolyn, welcome.
Thanks, George. It's good to see you.
It's good to see you again. As we were chatting before this started, we've known each other for a while. So let's start with that. So let's talk about what got you into all of this stuff in the first place, and then the path you've taken to get to where you are today.
Absolutely. I started out as a commercial litigator at Baker Botts in Houston, mostly handling large commercial cases of a variety of different kinds: energy, oil and gas, patent, accounting malpractice, sort of business litigation across the board. And in really the mid-90s, 2 things kind of coincided to get me interested in e-discovery. One was the influx of a lot of governmental investigations having to do with the energy industry. And the government was a little bit ahead of commercial litigators in terms of asking for electronically stored information. And the other was the initial Zuba Lake opinions. I actually had a case in front of Judge Shinlin, unrelated to Zuba Lake, but was interested in her. And when the opinions started getting a little traction, I started following them, especially because there weren't any rules yet that helped to guide me in how I dealt with the increase of my clients when I'd go interview them to collect documents saying, oh, well, all of that is on the server or it's in the database or something like that. So I got interested in it. So about the last 10 years or so at Baker Botts, I was really doing almost exclusively e-discovery. And from there, I moved into consulting. I did a lot of work with law firms and clients, sort of standing in the middle, being the translator between what the lawyers needed in litigation and what the IT folks were hearing from the lawyers, and translating for them what was necessary. And that sort of was a great fit to move into consulting. And then I had the opportunity to join these great folks at CDE who focus on specifically construction litigation. And there are a lot of unique aspects to the data and the data gathering process in construction that I've gotten the opportunity to focus on.
So I'd like to talk more about the construction side of things. But before we do that, why don't we step back a little bit and have you take a look at or talk about where e-discovery fits in the bigger picture of things?
You know, that's one of the things that that I see a lot in our conversations around e-discovery is that we don't spend a lot of time thinking about the litigation process as a whole. We tend to sort of put ourselves in that e-discovery bubble without a lot of perspective on what happens after we gather and produce the electronically stored information. So one of the things I think that has given me a little bit of an advantage in terms of the e-discovery world is having that litigation experience, that trial experience, because I understand that there are goals in addition to just gathering and producing the electronically stored information. I think for a lot of folks who think of e-discovery, we sort of think of ourselves as siloed, and we have to get past that. And we have to think about how we use the information that we gather in depositions, in motion practice, and ultimately in trial. And that really has to impact our strategies as we deal with the data from an e-discovery collection, processing, hosting perspective.
So let's start with depositions. How should people be thinking of using this data to more effectively take or defend depositions?
In a perfect world, I think we would all exchange our information natively, and we'd all be able to put things on the screen, show Excel spreadsheets and that sort of thing on the screen. But that's not the way depositions work. And that's not the way that lawyers, at least still, maybe in the future it'll change, but that's not the way that lawyers prepare for depositions. The way they prepare for depositions is they print stuff out. And they have an exhibit which they hand to the court reporter and ask the court reporter to mark it as exhibit 125 or whatever. And they hand a copy to the witness, and they have a copy which they've highlighted usually or made notes in the margin on to question the witness about. So we have to think about the way that lawyers still approach information. And for better or worse, it's largely paper-based still.
What can we do to change that? Should we change that? And if so, what can we do to change that?
Oh, I think that there are always going to be logistical challenges to that, because for one thing, lawyers don't want to show the other side what it is that they're going to ask their witness about in deposition. So it's not like we're going to be exchanging exhibits in advance so that you can, run an MD5 hash and make sure that the native file that you're going to be showing the witness is exactly the native file that was produced. Or for that matter, I don't think lawyers are going to be willing to run, a hash during a deposition to prove that it's accurate. I think we're actually, for depositions, we're probably stuck in the paper world for, probably at least for the rest of my career, until I retire, and maybe beyond that.
And yet they take it on faith that the paper copy is accurate?
Oh, absolutely. Absolutely. As long as it's got that Bates number at the bottom that reflects a Bates number that they've provided to the other side, they're usually pretty comfortable with it.
I think maybe 20 years ago, before that, at conferences, I would do a demonstration of how I could take a TIFF image of a document, go in and change the individual pixels at will to have it say all sorts of things it didn't originally say.
Sure.
And the Bates number would stay the same.
Yeah, and the image would change. Yeah, you can modify PDFs. You can edit PDFs now. The technology is wonderful. The practice of law hasn't quite caught up to it, unfortunately. And we've been dealing with that issue, literally for years with Excel spreadsheets. I mean, typically the approach is to produce Excel spreadsheets natively because they don't TIFF very well.
Mm-hmm.
And there are lots of formulas and things running in the background on Excel spreadsheets that could be readily modified, but we sort of operate on faith, if you will, there. We're not as willing to operate on faith with the entire production. Maybe the thought process is it's a little more controllable when you have a narrower collection of those native files that you're dealing with than, the entire 1 million or 2 million page production.
So you'd like to see change, but you don't hold out hope for any significant change in the near term or the rest of our careers.
It's very difficult to say when, technology makes these amazing leaps forward, and sometimes very, very dramatically in a short period of time. I mean, I don't know that many people were talking about ChatGPT, for example, this time last year. I mean, that really hit the news in October, November, and now it's everywhere. So who knows? Maybe 2 months from now, somebody's going to come up with a technology that does allow us to run a hash on a native file in a deposition with literally just a push of a button. And lawyers will magically adapt to that technology. Who knows?
Who knows? The construction industry poses very particular challenges and opportunities when it comes to industry. How does e-discovery and construction differ from e-discovery more generally?
There's several ways I think it differs. Number one is it uses a lot of unique systems and programs that you don't see in ordinary business litigation. To manage the kind of documentation that you have to have for a large construction project requires the capability to access a variety of different kinds of files, everything from CAD drawings down to just sort of your ordinary Excel spreadsheets, from a lot of different locations and by a lot of different people with various areas of expertise, the designer, the contractor, the builder, et cetera. So you've got the owner, you've got all these different people who may need this information. So there has been an entire industry that's built around managing that sort of information. So you've got Procore and BIM 360 and Kahua, and you've got all these very unique data sources that come to play, ACONEX, that come to play in the discovery process and litigation. So you've got these, sometimes I think you're confronted with data sources that you've not seen before or that you're not used to, and that are organized very differently than kind of your typical commercial litigation.
Does that mean then that, like so many things, you could divide the world of litigators up into two groups? Those who deal with construction litigation on a regular enough basis that they have a good understanding of what these data sources might be and how to deal with them, and those who don't deal with construction litigation as frequently and therefore may not be aware of these things?
The best case scenario is when you have lawyers on both sides of the case who understand the construction industry, because they know and they understand what will be required in terms of e-discovery. One of the most difficult challenges is when you have a novice, if you will, on the other side. And they tend to default to what most litigators tend to default to when they don't really know the area, which is, I want everything. Give me all of it. And that can often be a really bad result for them, because they wind up with not hundreds of gigabytes, but terabytes of data that they then have to sift through, CAD drawings and lots of other things, which may be relevant to their litigation or may not be, but they find themselves buried under a mountain of electronic files.
What do you see as a more successful strategy?
I think the federal rules really went very far into helping us deal with this issue. And I'm going to go way back to the meet and confer. I think you have to sit down early in the case and talk to the other side about what you each have and what you each need in order to defend or prosecute your case. And you have to focus in on that. So I'm a big fan of the ESI protocol. I think that you have to have those discussions up front, and you have to document it in the ESI protocol so that everybody knows what the rules of the road are. And that's not to say that something might come up. Having been a commercial litigator, I see this a lot, where litigation sort of takes a left turn, 6 months or a year into it, and you might have to go back and rethink those and renegotiate. But if you start with a game plan, just like our clients start with drawings and blueprints and plans and schedules, then you have a better sense of how to manage that volume of electronically stored information and really get to the meat of what you need early so that you can then prepare for everything that comes after e-discovery.
Do ESI protocols for construction litigation differ from those for more general litigation?
I think they do in a couple of ways. One is the sources, the discussion of where you're going to get your electronically stored information. So if the parties know and understand the systems that are used, that is tremendously helpful. And in a lot of construction cases, the dispute involves information that may be in a database that both sides had access to. They jointly shared information. Sometimes owners will establish a database using one of these tools that I talked about earlier, and everyone has access. They can put information in, they can look for information. And so one of the things I think needs to be discussed up front in a case is how you're going to produce or make available in the case, maybe a better way to say it, that sort of jointly created database. Who actually owns that database and who's responsible for producing it? Because I think the last thing anybody wants is a lot of time and expense spent on exchanging the same information back and forth that people are pulling out of the same repository and just spitting it back in discovery. It costs everybody more money, and it doesn't really advance, again, the litigation ball. It's e-discovery for e-discovery's sake almost.
What successful approaches have you seen to taking on that type of challenge, the shared database, for example?
One of them is identifying the owner of the database and having, if that person is, or if that company is part of the litigation, having an agreement that they produce that or make it available. Other options are that I don't see used as often, but I wish would occur more, is a shared database, a joint database, where the parties agree to put the information into a repository that everyone can access, and they share the cost of hosting that information during the course of the litigation. To me, that's the most cost-effective way to manage it. Unfortunately, we don't see that as much as we'd like to see it.
What do you think the barriers are to that?
I don't really know what the barriers are. I would say that it's probably, for lack of a better word, tradition. It's not something that has been done in the past. And lawyers, as you know, are sometimes kind of slow to move to other ideas. I think clients might be likely to embrace it pretty quickly because they're the ones who bear the brunt of those monthly hosting costs. There are probably some logistical challenges to it also, like making sure that everybody pays their fair share if they're jointly hosting. But good lawyers could probably create some paperwork to make that work out.
Do you run into situations where one side is using a very specialized set of technologies designed for construction, and the other side doesn't have access to those tools but wants the data from those systems? How does that get dealt with?
The interesting thing is, if you think about a lot of these tools that I'm talking about, they're almost like a library, where they have a folder, where they have a defined folder structure. And within that folder structure, you have individual data and documents. So you produce the information kind of the old-fashioned way, if you will, with, here are the CAD drawings, here are the change orders, here are the what's the right word? The invoices for the equipment that was needed on site and that sort of thing. So you produce it sort of the old-fashioned way, but you just don't have the advantage of the structure, if you will.
This takes us back in a way to depositions, hearings, and trial. When you've got things like CAD files, at least some of which were never really meant to be seen only on paper, how do you make effective use of those in those three settings: depositions, hearings, and trial?
think it's a lot harder in depositions, but at hearings and trials, you have the advantage of the technology in the courtroom where you can use those native files. And the great thing about trials is you exchange your exhibits in advance, which is sort of the hurdle in depositions about using a lot of native files. So the other side knows it's coming, and they know and can confirm that the file is accurate. But I think that's going to be a huge issue with regard to lawyers working with each other in advance, making sure that those documents or that those files can be used effectively. I think it's helpful for the jury, if it's a jury trial, to be able to see the files that the parties were working with as they would work with them natively. And unfortunately, lawyers are going to have to adapt to that.
Well, it's a new world. You just need a chat GPT for that, right?
I'm a little worried.
Yeah, not so much.
What you may have seen already, some lawyers are embracing the new technology. Allen and Overy just announced that they've got something they call Harvey that's based on chat GPT.
Right. I mean, I've seen both articles about law firms that are beginning to embrace that technology and articles about law firms who are beginning to embrace that technology but don't appear to have given much thought to the implications when it comes to things like their own information governance.
Yes. And it's interesting because I saw a great analogy that I'm going to apply to this. And I actually used this when I was teaching a CLE the other day. I want lawyers to understand the difference between the kinds of artificial intelligence we use in the e-discovery world to sort of sift through documents and chat GPT, which essentially, other than being provided a prompt, kind of works on its own. And being a fan of superhero and action adventure movies, this analogy really struck me. And it's the difference between the Terminator and Iron Man. And ChatGPT is sort of the Terminator. Essentially, you create something and then it goes off and does what it decides to do. That is, write up or create whatever it is you've asked it to do. And artificial intelligence in the e-discovery world is more like Iron Man. That is, you are Tony Stark. You're the superhero. You get in the suit of artificial intelligence and you tell the suit what to do and you control it. So one thing that I'm a little fearful of for the lawyers who haven't kind of jumped into the world of artificial intelligence in e-discovery is that they're going to kind of mash up the two and become very skeptical of artificial intelligence in e-discovery, thinking that it's like chat GPT.
Right.
And so I thought that analogy really was helpful in talking with folks who are sort of new to the AI world in e-discovery, Brainspace and that sort of tool, because we're not that. We're not chat GPT when we use artificial intelligence. We're Tony Stark.
Right. One of the things that, of course, happens in this whole process is not only that parties produce, but parties receive data. And there's so much that they could be doing. What are some of the particular challenges and opportunities when it comes to receiving data within construction litigation?
So again, when you're exchanging information in these kinds of cases, it is voluminous from both sides. And one of the things that I think is very useful is to use artificial intelligence on the incoming data. For the same reason that we talked about with regard to the information, there's a lot of stuff that's going to be responsive to your discovery requests. The question is, what do you really need in order to litigate your case? Going back to sort of what the whole purpose of the discovery process is. And if you've used artificial intelligence on your data to review it for production, or to analyze it in other ways. Maybe you didn't use it to make the decisions on whether or not to produce, but you've looked at it to determine if you've got, if you've got certain issues in there, or to decide what is most important, or to even prepare your own people for depositions. Then you have that model built that you can apply to incoming data and see if you can sort of float the cream to the top and find the important documents that you need to look at for purposes of your depositions, your motion practice, and ultimately for trial. You can also do some other things with artificial intelligence that are a little more run-of-the-mill, like you can run a timeline and you can look to see if there are gaps in the information that the other side has provided. So you're checking to see that you got a full and complete production. You can run particular individuals' data. So if you see somebody getting, thousands of emails a month, and then all of a sudden for 2 or 3 or 4 months, the number of emails from that individual goes way down, that may spark you to go back to the other side and say, hey, is there a gap here? Is there something missing? Why do I not have this information? So it's very useful on a lot of different fronts.
In addition to using AI to develop timelines, how else can you use AI to help bring that cream to the top?
In a lot of cases, discovery, the requests for discovery go over a very, very long period of time. The dispute may really center on certain key meetings or points in time where something developed. And the great thing about AI is you can really dive into those specifics. Otherwise, you're sort of skimming across the top like a rock skims across a pond, but there's a lot of information that may be deeper in there. And you can utilize AI when you hone in on those kind of key decision points or those key actions to see what everyone was doing or what was going on within organizations in a number of different ways. And we found some pretty interesting stuff doing it that way.
What are some examples, properly sanitized, of course, of some of the interesting stuff you found?
I think that some of the most telling things is what communications are going on, say, at the management level when there's an issue that's sort of bubbling up down here. And so what goes to what kinds of communications and what information goes up to the senior level and what doesn't can be very telling. And so sometimes if you look at the communication patterns, you can figure out that whether, say, the other side knew that there was this issue and felt the need to report up the chain, and whether some of those folks knew there was an issue and declined to report up the chain. And those can be very telling in litigation. They can be very important to a litigator to show the mindset of what was going on with the witnesses on the other side.
You're presenting all sorts of opportunities. How frequently are construction attorneys availing themselves of these opportunities?
I think that construction lawyers, because they've been dealing with these large volumes of data for so long, my experience has been that they are more receptive to using this sort of technology. And part of it may springboard off the fact that their clients are using artificial intelligence in their work, because I'm sure everyone has read in the press that there is a shortage of skilled construction folks. And so a lot of our clients are supplementing their workforce with artificial intelligence. Some of the people listening may have seen the robots that look like dogs, that they walk construction sites and take photographs and show, real-time activity. They can identify potential hazards or issues in the construction and that sort of thing. Instead of having an individual walking around with cameras, they're utilizing the technology, because that way they can use the people for other things that they need, and they're supplementing their workforce that way. And so when you go to a client as a construction lawyer and say essentially, I want to supplement my workforce, that is my document review process, with artificial intelligence, it's really going to help me identify the information. It's going to be cheaper, it's going to be faster, and it's going to really help our budget in the litigation, because let's face it, a lot of money goes into litigation, and the clients are sensitive to that. You can use that artificial intelligence to help manage your budget and still get the result that both you and your client are looking for.
Well, thank you, Carolyn. I do, by the way, look forward to the day when someone puts one of those robot dogs up on the stand to deliver testimony at a hearing or a trial. That will be very, very interesting. But thank you again, Carolyn. Carolyn Southerland is a senior e-discovery consultant at CDE, Construction Discovery Experts. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. And once again, Carolyn, thank you so much.
Thank you, George.